Hi, I'm Lise Wheel with Law&Crime. We've been watching the Tex McIver case. Fascinating case that it's been undergoing today. We've had both the defense and the prosecution openings today as they set forth their theories of the case. In my estimation, both of them doing a really superb job in putting forth the facts. They really were coming, both of them, as close to, I believe, Julie Rendelman, as I have you here in the courtroom. At the courtroom here, the courtroom. It really does feel like a courtroom here, the courtroom of Law&Crime. Right. It really did feel like in their opening statements, both the prosecution and the defense, that they were coming as close to arguing in their opening statement as possible. In fact, even as the defense was putting on her opening statement, there were a couple of times where she drew an objection from the prosecution, and the objection was exactly that she was being argumentative. Of course, you're not supposed to argue your case in your opening statement. And what she said right back to the judge was, "This is what I intend to prove. I will get to that. Judge, just give me a second. I'll get there."
All it requires is those words, is "this is what I intend to prove," and then you basically can say whatever you want.
Exactly.
It is summation and arguments.
Exactly.
So as long as you say that. But yeah, I mean, look, both sides' job is to argue their case, even on opening. You just can't make it clear to the other side and to the judge that that's what you're doing.
Right. And there were a lot of opportunities in that opening, especially for the defense, to really introduce their defendant to the jury. And there were a lot of times when the cameras were panning to the defendant, Tex McIver, and you saw him sort of welling up with tears and, looking very sad and emotional. There have been times where, boy, I sound so cynical. Gosh, I guess I've watched a lot of trials.
Oh no!
Oh no! But there are times when a defendant will just sort of look stoically in front, and even in a capital murder case, and not have to show any emotion at all. And that was absolutely not the case with this defendant. He showed he wasn't breaking down and sobbing or doing any of that. It wasn't overboard, but he was showing some emotion. He was there. There he is right there. You look, he's sort of sobbing. Not overly, but you can see he's dabbing his eyes there.
As long as tears come out, I think that can be effective for the jury. I mean, look, you as a defendant, as a defense attorney, as a prosecutor, the jury is watching you at all times.
Absolutely.
And in a case like this, the community is watching you at all times because this is publicized. So you want to portray a certain image to the general public and to the people that are deciding your fate. And so the defendant is towing the line as to how he's going to behave in that courtroom. And I'm sure he's gotten, I don't want to be cynical either, because I'm not questioning guilt or innocence, but there's no question the defense attorney is going to have a conversation with him about how he needs to behave in that courtroom at all times.
Right, because as you know, even if some of the jurors are watching the attorneys or the judge or even the court reporter, there are others that are watching the defendant
at all times.
Exactly, and looking, and they will come and report when they're time for deliberation. Hey, I saw what the defendant was doing. He was laughing or joking or posing for the cameras, or he was looking very sad at the opening statements.
Right.
Now, in both the prosecution and the defense, as I said, they were very factual. They went through fact by fact what they thought were extenuating circumstances for their case.
Right.
And in both cases, both prosecution and defense, now, the defense obviously doesn't have to prove anything, and the prosecution does not have to prove motive.
Right.
But both did go after motive primarily in these opening statements. The prosecution really going after, you've got both people relatively wealthy. Diane, the victim, died when apparently she was worth $12 million. There's a picture of her. Beautiful woman. She died. She was worth apparently $12 million.
Right.
The defendant, a very well-known attorney, was a partner at a firm when he left, and was making, in 2014, we learned he was making $350,000. It was less than he made while he was an active partner, but still, that's no chump change. That's a lot of money. Right. He was making a lot of money. He was making less than she was, and the prosecution made a point of that. Less relatively than she was. She was becoming more of the big earner, the things, yeah, the big breadwinner. Tables had kind of turned and shifted a little bit in the course of their marriage, both second marriages for both of them. There were papers that were drawn up about loans, a lot of talk about the loans that she had given to him. One loan, apparently, he had only been paying off in interest payments to her, hadn't made the principal payments. There was a big deal about that. So money was a big factor in the prosecutions, and you're hearing that now with some of these opening witnesses.
Yeah, I mean, money seems to be the only factor. I think, you know, I think there's really, that's the only factor that we're considering, because I think the problem for the prosecution is without this motive of financial gain, you have nothing, because initially they thought it was an accident. It's not until they start to look at what could be the motive that they start to talk about it being less than an accident. So of course the prosecution does have to focus on that, which is what they did.
Now in the defense opening, they say the money is absolutely not a motive, because why would he kill her? She was making all this money. In other words, why would he really kill a cash cow?
Right.
I mean, to put it bluntly, she was making all this money. He loved her, and of course the defense makes a point of that. But the defense also goes on very specific. There was no motive for him to kill her. He relied on her income.
Right.
The defense attorney goes out and says he relied on her income. So why would he go out and kill her? So both sides, both the prosecution and the defense, pin money as a motive, but both argue money differently.
Exactly. Right. No, I agree with you. I think the biggest problem that the prosecution has is the circumstances surrounding her death. And, you know, how do you prove that he intentionally killed her? Right, but there's a lot. Look, I mean, we haven't heard a lot yet.
Yeah, exactly.
But you know, it depends on whether or not the gun was cocked or not. You know, whether you know how much it required in order to pull the trigger. And I think there's going to be a lot of evidence regarding his sleep habits, like whether or not he woke up stirred, because that could be a factor in why he might have awoken to think that they were in danger or something like that. There's going to be so much going on.
That's why the first witness for the prosecution was a friend who said that he knew a lot about guns and a lot about gun training, and so he would know about, you know, not just waking up and just letting a gun go off, because he knew a lot about guns and he had trained others in guns. So it looks like our 5-minute break is over, and we will go back to the courtroom live. I think we're ready. Here we go. Okay, we're right back. We're not quite ready to go back to the courtroom, but we do have a clip from the defense that we're going to go to, so we'll go to that right now.
Ladies and gentlemen, my name is Amanda Clark Palmer. We just spent, I think, maybe 30 or 40 minutes listening to the state tell you all their theories and their reasons why they think Mr. McIver intentionally shot Diane McIver. And I want to tell you that you can just set all of that aside. There's really one thing that you need to know about Tex McIver and Diane McIver to know that he did not intentionally shoot his wife, and that is that he loved her. He truly loved her, deeply loved her, and she loved him back. You are going to hear from multiple witnesses that they had a relationship that people were envious of, that they seemed like lovebirds even after 10 years of marriage, that Tex adored Diane, that she loved him, and that they were clearly proud to be married to each other. Nothing the state will present to you will prove that this was not an accident. So let me start by kind of going through the timeline of September 25th. And again, this is an area where probably we don't have a lot of disagreement with the state. Danny Jo Carter and Diane and Tex drove out to their ranch in Eatonton, Georgia, which is near Lake Oconee, on Friday, September 23rd. They all went out there together. They had a wonderful weekend. They had great weather. On the afternoon, the day in the afternoon of Sunday, September 25th, Tex and Diane played golf. They had a great round of golf. I think Diane beat Tex. She was an excellent golfer. Danny Jo was riding horses. And after they got done playing golf, it was kind of in the late afternoon, evening, And that was when it was time to head back to Atlanta. So they leave the ranch. They stop off at the Longhorn in Conyers, where they meet Craig Stringer, who is a co-worker or colleague of Diane. I believe he had also been playing golf with them earlier that day. He meets them at the Longhorn restaurant, where, yes, they share dinner. And by the time they leave, I think you'll hear that it was maybe approximately 8:30 at night on Sunday when they left. So they start driving back to Atlanta. The state showed you part of the route that they used to drive back to Atlanta. Again, a fact that's not in dispute. They go on I-20, and when they get to the connector, they hit a traffic jam. There was some construction going on the interstate, so traffic was really backed up. At this point in time, Tex has fallen asleep in the backseat of the car. He fell asleep on the ride from Longhorn into the city. And so Diane is the one who tells Danny Joe to get off the interstate. Diane is familiar with that area down there. She knows how to use the surface streets to get from the Edgewood exit area back up to their condo in Buckhead. So she is giving Danny Joe the directions. They get off at the Edgewood exit, as I say, and at that point in time, Tex wakes up and he looks around. He says, "Girls, I think this is a bad idea," or "I think this is a bad area."
That's from previously recorded information or the openings this morning. Now let's go to the courtroom, which is going on right now.
You a Buckeye or Boilermaker?
I'm a Buckeye.
Would it be fair to say, Mr. Quillen, that you are intimately familiar with the inner workings of the firm?
Yes.
Are you kind of, to use the phrase, like the buck stops here, are you that guy?
Yes, I am.
And can you tell the jurors about how many employees does the Atlanta office of Fisher Phillips have?
Presently, we have about between 35 and 40 lawyers, and then we have about an equal number of non-lawyer staff support.
Okay. And could you tell the jurors where exactly, physically, is Fisher Phillips located here within the city of Atlanta?
Our office is on the 34th and 35th floors of the building at the corner of 12th Street and Peachtree Street.
So, kind of in layman's terms for non-lawyers, performance standards would be what? Give us an example.
We expect an equity partner of the firm to put in a level of billable time, that is, hours that they work in the interest of clients and record them so that they can then be invoiced to the client for payment. And there are threshold standards for business development that we expect from equity partners as well. Now that's more fluid, I have to say. As a partner is reaching the end of career, we're not real dogmatic about what that business development standard has to be, but what we're mostly talking about is what are they able to do in terms of the hours commitment, and particularly the billable hours commitment that they're able to make. And when we see that reducing, that's usually a sign for us we need to have that conversation.
And was that the case with respect to the defendant?
It was.
And so, on the one hand, partners are expected to bill a certain number of hours to clients already in existence.
Yes.
Partners are also expected to develop new business.
Yes.
Objection to leading, Your Honor. I mean, it was a couple questions in a row there.
Okay. I mean, should I set some framework here, but let's keep it a little more open-ended.
Yes.
Apparently touched it up.
Yes. Okay.
Okay, so the prosecution has on the chairman of the law firm that the defendant, Tex McIver, used to work for. Started in 1972. In fact, have the letter that Tex McIver said, "Yes, I'm going to accept the employment at the law firm." Who has a letter from 1972, Julie Rendelman? But anyway, they had the prosecution. Yeah, it must have been a lot. And he worked there until the end of 2016, December 31st, 2016. So 44 years at this same law firm. And in the course of time, billable hours, which of course you know, Julie, is what lawyers live and breathe and die and all of that jargony stuff by, his billable hours went up many while he was going at it, and then performance started to go down and billable hours started to go down as the young guys got in there and gals got in there, and their so performance went down. So he was a partner for many years. And what this chairman is trying to talk about is the difference between an equity partner and an income partner. And the whole thing that they're trying to make the point of here is money. He was making less of it. So, right. Julie, tell us what the prosecution is trying to do here.
I mean, look, if I was the jury at this point, my eyes would be shut and I would be, snoozing away.
But we're not snoozing here at Law&Crime.
Because I don't think it needs to be this complicated.
Right.
All you need to basically say to the jury is he was making money, he's making less money, he was starting to borrow money because he didn't have enough money, and that was the motive to kill her. I don't know that you're getting anywhere with going through, every year of his life as to what he was making and what he wasn't. And I think you start to lose the jury. And if I was the defense, I would hit hard on that when I got up.
The other issue, do you think it hurts a little bit that the size of money that we're talking about, nobody's poor here.
Right.
He was making $350.
Yeah, it's also not like he's living in New York City where,
it costs so much.
Right. Studio. I mean,
right.
But,
lived in a ranch.
Right. He did have, I think it's true that potentially he did have money issues. The question is, did those money issues cause him at the age of 73, after really never committing a crime in his life, to take the life of his wife? And that, to me, is a hard sell in this case.
And do it in such a strange way, in the back of a car.
Right. Some would argue that it was one of those moments where it's like, wow, here's my opportunity.
Let's just do it now.
Let me do it now. I'm having trouble with it. Certainly to prove it beyond a reasonable doubt that he intended to kill her.
Okay, but for right now, step by step, they had the first witness on. This was a friend of the victim, actually, who said, well, friend of actually both of them, who said that Tex had knew a lot about guns. He was around them all the time and trained people in them. So kind of getting at the fact that, wow, he wouldn't just wake up and just go, woo, I don't know what to do about a gun, and it would just misfire. That's going on there. She, by the way, had dated him back in the day, but they just kind of threw that out there. Friends are friends. And then now this guy is the chairman of the law firm that he worked at for 44 years, is saying that he used to be an equity partner, now is not an equity partner, made a lot of money, and is making less and less and less and less and less. Again, going at the money is the motivating factor. So he is still on the stand. Let's go back, and we will pop in and back and forth as need be. We'll go back to the stand and hear from the chairman of the law firm.
3-year basis. So we don't make a lot of salary decisions based upon a 1-year performance, but based upon the rolling 3-year record, we do.
Okay. Should we go to 166 now? Talk about, yes.
Unless you want to talk about the business development part of this piece of paper.
Yes. Can you summarize that for the jurors, the business development part?
Sure. So partners of the firm also have tailored, that is personalized, business development goals as well. So to be a partner of the firm, not only an equity partner, but even many or most of our income partners, we set for them an expectation of the dollars that the firm will receive in payments from clients, in payment for services that the firm has rendered. And the clients he's getting credit for, or any lawyer is getting credit for, are clients that he originated to the firm. That is, he was the reason the client came to our firm. Or there's another way, and that is to generate new matters from the firm's clients, clients that someone else has originated. So the sum of those two forms of so-called business development dollars is that number that you see, his O&R received. So if you, right there. So we're zooming in there. If you look to O&R received, the raw dollars that were paid to the firm by clients for the firm's services that he got business development credit for, those numbers in 2013 were $1,087,000. In 2014, not much difference, $1,064,000. In 2015, $1,047,000. But that's not the end of the story, because we also do a profitability analysis in our law firm. We don't treat all business development dollars that arrive as being equal necessarily, because some client relationships are more profitable than others. And so, having done our profitability analysis, what we credited him for in those 3 years was, in 2013, he was credited with the raw number, $1,087,000. In 2014, the dollars he brought into the firm were deemed by our financial department to be highly profitable, and therefore they were grossed up in our treatment to $1.3 million plus. In the last year on this sheet, 2015, the $1,047,000 of dollars that actually came through the door were analyzed as being considerably less profitable than the firms on average, and therefore, in our reckoning, as we were examining his performance, we treated his business development dollars for our purposes as $769,000. Out to the right, you will see that you'll see out there at the extreme right of that long box, in 2015, the expectation for Tex in that year was that his business development dollars would normalize to $1.5 million or more.
And so his business development there at the firm was going down.
Well, just to be clear, from 2013 to 2015, his business development dollars, raw dollars that were arriving in our receivables department, those raw dollars were drifting ever so slightly downward. If you look to the profitability of those dollars, you'll see that in 2013 it was just like the raw dollars that came. Then he got credited with a lot more than came in, and then the next year he got credited with a lot less than came in. But in every case, missing that standard by a wide margin. And that standard, while I don't have it on a piece of paper for 2013 and 2014, I am absolutely confident that that standard was never less than 1.5. It could possibly have been more at one of these earlier years, but it was definitely not less than 1.5 because the standard was being reduced as time went by.
Okay. Now, State's Exhibit 166, does that include the calendar year of 2016?
Well, not calendar year, but again,
I'm sorry.
Yes, that reporting year.
Yes, reporting year.
Yeah. So the difference between.
Hello, I'm Lise Wheel with Julie Rendelman. We're back here. We have again the lawyer, the chairman of the law firm that Tex McIver worked at for 44 years. Going on about business development and profitability, even on business development. What happens there in a law firms, especially big ones like this one, is that you have not only your paycheck coming from those billable hours where you make money and you have a target. The target for the defendant, Tex McIver, was about 1,700 hours, but that was lessened as he got older. It became around 1,000, about 1,000, 1,100, and he had to meet that target, and he wasn't for some of the years, but he was making it up somewhat with what they call business development, where partners have to go out and they have to get new business. They've got to go schmooze at the country club, at the golf club, whatever. They've got to bring in new clients, and they get credits for that. And there's literally a line in that this partner was talking about, the chairman here was talking about, with business development, they bring in a new client because you need that for a good firm, for any firm, to keep growing. So you need bringing in clients. So you have to compensate partners for bringing in those clients. And even within the business development, they have profitability standards within that because some clients pay the bills and come back and bring new clients and bigger clients. Some clients are like Coca-Cola. They're big and they're going to be coming back and forth. And some clients aren't so big and maybe they're not going to pay their bills and maybe they'll come only one time for some small little matter, like a small tiny divorce, and then they don't pay their bills and they never come back. And so that client business development, you're not going to get that much credit for it, right, Julie Rendelman?
Right.
It's not going to come out that big. So that's what this partner is talking about. And he's talking about how that relates to this particular defendant and how his profitability at the firm was slowly and maybe not so slowly dwindling down. Why is all this so important, Julie? Because I think what they're trying to do in the prosecution is show motive, and that is Tex had it because he didn't have money.
Yeah, I mean, I hate that I'm rolling my eyes again, because I think I rolled my eyes at the last trial with Jesse, and he was like, "Why are you rolling your eyes again?" And I admit that I'm bored, and I admit that I understand where they're going. I don't know that they need to do this to get there. And so a couple things. One of the things we were talking about is, when you're a prosecutor and you open on your case, you want to begin with a bang. You want something that's going to get A, the jury's attention, B, get the jury buying what you're selling. And I don't think starting with the first witness, which was the friend, and then going into two people that worked with him that can literally talk from 1972 until now is going to have the jury's attention to believe that he is a murderer. And so I'm shocked that this is the route they're going. I'm shocked that they're spending so much time on it. I said to you a few times ago, am I missing something? Because can't they make this point a lot more simpler? Either he had no money and he had a motive, or he had money and he had no motive. So I just want to get to the point, because if I'm bored and I've been, handling these type of cases for years, and you're bored and have been handling these cases for years, imagine what the jury feels. Well,
and place yourself in that jury box, and you are there to hear a murder case, and you've been all primed up, right? Because you've heard both the prosecution and the defense opening statement, and we've seen the defendant, sobbing a little bit. You're all primed up. You know there's a dead woman there, and you want to hear the evidence. You've heard about gunshots. You've heard about this forensics you're going to hear. And then what does the prosecution start with? A friend. Okay, that's all right. But then you put this guy. I mean, it's nothing. It's not his fault. He's the chairman of a law firm. It's what he does. It's kind of boring. I'm sorry. And you go on and on and on with it. This guy would be kind of a middle-in witness if I were putting on the case. I'd kind of slide him in there, kind of in the middle of my case, get him on, have him got to do what he's got to do, establish that motive, and then get him out.
Simply having less money than your wife does not mean that you're going to kill her. I mean, it just doesn't, it's not that simple.
Put it in there.
Of course it can be. And it seems to me right now, and again, we're very early in this trial, or maybe we're not, but it seems like we're early in this trial, so I'm making several assumptions. I hope there's more than this, because I am not, as a juror, going to hang my hat on this being the motive to kill this woman.
Well, that's the problem, you see, is because we want something, we're doing exactly what we just talked about. We want something quickly up front, and we're not being given that as we're watching it. And as jurors, it's like, okay, where's the big stuff? Where's the meat? I mean, obviously, you want something at the end, sort of bookends in a trial. You want something to get started, and you want a lot of stuff in the middle too, and then you want something at the end so that you remember. Your mind just works that way. You want something to get beating. Oh, I remember that when the prosecution put that on. And then there was a lot of stuff in the middle that I remember as well. And then I remember what they ended with. And you have that as a juror. But this, I mean, and again, it's no offense to this guy. I'm sure he's a really nice guy with a nice family and all, a nice law firm. But talking about business development and profitability and equity partnering,
I think we're going way too far afield.
Ooh.
If I'm the defense, I'm pretty happy right now.
Yeah.
Yeah.
Okay. I guess he's still on the stand, and we'll kind of go back to him, and we'll be back. We'll be back, guys. We'll give some more analysis, but let's go see this nice gentleman on the stand and see what he's got to say. Hey, you're learning about law firms and business development and profitability and income sharing and all that kind of stuff.
Plans to retire at the end of 2016 instead of dragging this out to the end of 2017.
But some folks like to have little breaks that are closer together. That's just how it's worked today. So we're going to take a little break, 5 minutes-ish. As soon as you guys are ready, after 5 minutes, we'll bring you back in here. If you need more time, you can take it. Don't talk about the case or do any outside research while you're back in the jury room. And we'll get you back in here. Thank you.
All rise for the jurors.
Okay, it looks like they're taking a break there in the trial. I think we're done with the law firm for a bit anyway.
For 5 minutes.
For 5 minutes, we get a break. Everyone out there in law and crime world, we have learned a lot about law firms, I guess probably more than a lot of people would want to learn. Business profitability, business development, billable hours. But we were just talking about it, Yes, they've certainly established that the defendant billed fewer hours as he got older,
right,
and as he moved from being what they called an equity partner, someone that actually had ownership in the firm,
right,
to an income partner, somebody that didn't have ownership in the firm but merely took a salary, so really was a partner in name only. Also, then didn't have liability in the firm. But then I'm getting into that, and then I'm taking the stand and tell you way more about law firms than you want to know. But there's really, and it'll probably come out in cross-examination, there's really nothing sinister about that.
There's nothing sinister.
That happens all the time when people get older and they want to sort of phase out gently of a law firm, right?
Absolutely. And so if there's nothing sinister about it, then the only thing that's relevant is that he was making less money.
Right.
I don't know if they're arguing, we were talking about this before, are they arguing that he chose to make less money because he was more reliant on his wife, and therefore she was going to potentially cut him out of a will, that he
and that would give him motive?
That he would have the motive? I guess so. But if we all agree that as you get older, sometimes some people want to work all the time, but some people want to slow it down. And we were actually saying maybe he wanted to slow it down and spend more time with his wife.
Right.
But there's nothing that I'm hearing, and I agree with you, there's nothing that indicates he was doing anything wrong at the firm that was causing him to lessen, the billable.
In fact, they were talking about some of it may be made up by the lack in his hours being made up by business development and profitability.
Well, so you don't. He was bringing in business. He just didn't have to work as much, which happens all the time.
Right. As you get older, you know more people, therefore you bring in more business. And by the way, if you're a bad lawyer and you've got a bad reputation out in the community, it's usually harder, one would think, just common sense,
to bring in business. Absolutely.
So. But he was making those hours up by bringing in business. So, everything that I'm hearing here is not so damaging, really, from a perspective from the defense.
I absolutely agree with you. Again, it's the beginning of the case.
Right.
We heard from the last witness who was a little more clear in terms of what he was making this year and what he's making this year.
Right.
I want to know how much he had, how much he made before, what his lifestyle was.
How much was he relying on her?
Exactly.
Was she just about to change the will in favor of the godson?
Was it 2 years ago or was it last week?
Right.
I mean, so these are the things that we should know, but I hopefully we'll get to them. And quite frankly, the thing I'm most interested in is what is the evidence inside that
car
vehicle that says this was an intentional act.
Right. And what did he do? How did he react? What were the things about? There were things about, did he get to the hospital in time? What did he say? Did he tamper with witnesses? All of those things. And I'm just sort of like, as a juror, I'm kind of like, why am I brought here? And I've heard all of these exciting openings because both sides gave, I thought, a very good opening. And then I'm not like given a little bit more to chew on. And I've got now a break and I've had all this time. And it's like, okay, we're getting now into the end of the first day. I want something more.
Right. Absolutely. I agree with you. I think I'm surprised that this is the way they're going, but hopefully or not hopefully, they will have more evidence that supports their position. I just, again, I hate talking about it, but we're talking about it because he's still on the stand, and we've been sitting here for how long, and he's still on the stand talking about the same thing. And I actually am very curious how the defense is going to cross-examine him, because I think that you can effectively use that witness to your advantage as the defense. So I think that will be more interesting than anything we've seen
with this
so far.
witness. I think wouldn't it have been maybe just a little simpler to have put him in the middle of the trial somewhere, and B, I know this sounds so old-fashioned, but do something with a chart.
Well, I don't think that is old-fashioned. I think that's quite the opposite.
Boom, boom, boom.
I think we have modernized courtrooms where we are able to do PowerPoints all the time.
Right.
And if you want to lay it out for the jury, just lay it out. Now, maybe they're going to do it, which, by the way, I hope they don't, because that just means another hour for this guy on the stand that we're going to have to sit through. So I hope that that's not the way they're going. I hope that they're just going to be finished with him. But I still haven't heard anything about what McIver did or didn't do in regards to this firm that makes him guilty of murder.
Nothing.
No.
Nothing, there's nothing here at all. I mean, it's all,
Speculation.
Speculation. He was there. And in fact, in a way, I don't know if the prosecution realizes that they're doing this, but they're almost in this guy, this Roger guy, this chairman, they're almost, I've just thought of this, they're almost putting on a character witness without realizing that they're doing it. Because he's been the chairman of the firm for a long time. He put this letter on of acceptance of employment from 1972.
Such an excellent point you're making.
Right? This defendant has been there and been employed for 44 years as an attorney.
And they've kept him as
an equity partner for 44 years. The only reason he kind of slacked off in the last couple of years is because he was out there in the community, business developing, churning to get more business for this firm. I don't know. I think they unbeknownst to them,
he's back.
They're putting on a character witness, and let's go back to the unbeknownst character witness for the defense, which is really a prosecution witness right here on the stand. Is he taking the stand? Let us see.
Maybe they hear us and realize that they should take him off the stand.
I don't know. That is not what they intend to do. But you see what I'm saying? I mean, they can't do that. Defense can't put on a character witness, but
no, but
and they don't need to. But the prosecution
I think that's exactly why we say that the defense can use him to their advantage by saying he's been with you for how many
all
years?
These years.
You've never had these
never had a
issues with
problem.
him. You've trusted him. You trust him to bring a business.
Have you ever seen an anger problem? Have you ever
Exactly.
seen any kind of issue with him?
You better know the answers.
A little bit, yeah. Well, exactly. Who knows? Who knows? I mean, I don't, want to paint that picture, but it's just an interesting gamble that the defense might just be thinking of.
I think we have the.
I think we're going back to the courtroom. Let's see what's going on there.